Welcome everyone to this Privacy Rules Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. Today I'm joined by Michal Nulicek from the law firm ROWAN LEGAL based in Czech Republic and the member of the Privacy Rules Alliance. And the reason of our invitation to Michal to join us today is a very interesting case that is under discussion at the moment in Czech Republic that regards Avast, a well-known company, and a potential fine, I would say, Michal, correct me if I'm wrong, from the Czech DPA. So, without further delay, Michal, why don't you provide us with a little overview? And of course, thanks a lot for being with us today.
Thank you for having me, Alessandro. First of all, well, before we go to what happened, I would just like to highlight as a lawyer at the beginning, a short disclaimer. This is what we have, what's publicly available at this moment is an unofficial translation of a first instance decision. So just for everyone to understand, Avast has most likely appealed the case, the first instance decision, which does not have a binding effect at the moment. So we have to wait till the final outcome for the decision of the chairman of the Czech DPA. As regards what happened, well, for those that have read through that decision, you know that this is a case that dates back to 2018-19, when allegedly Avast, one of the largest antivirus companies, was transferring its user data to its group company JumpShot, a company based in the US, for various business purposes, analyzing trends, further commercial exploitation, and so on. The problem that the Czech authority has here is that firstly, Avast was doing it on the basis of a widely, or I would say wildly, interpreted legitimate interest rather than freely given consent of the users and without properly informing of the users about the purposes and the legal basis of the processing and so on. Maybe two things to mention here. First, well, what I think is that if you look at the privacy policies that are cited in the decision, it included some information and promises of Avast not to do the precise things that it was doing. So perhaps the authority also took that into account. It's not only about not providing information, but perhaps also misleading the users. Another important aspect to understand is that we're talking really big data sets, quite sensitive data, such as, search histories, YouTube videos views, coordinates on Google Maps, and so on.
Yeah. Thanks a lot, Michal, for this brief, overview and very interesting points. Of course, in particular, the one that you were mentioning related to the fact, that there was something stated that was not respected. This is something that normally, privacy lawyers in particular underline not to do because it's the first thing that then companies want to check. Speaking about this, just one quick thing that maybe we would like to mention. The case was initially discussed and opened in Spain, but then, debating in Czech Republic. Can you explain us a bit how does the mechanism work and why we ended up in Czech Republic?
Absolutely. I mean, this is I think a fascinating example of the one-stop shop principle working in practice, which means that the supervisor for cross-border processing, the supervisory authority of the main establishment of the controller is the lead one. So Avast has headquarters here in Prague, the Czech Republic. The Czech supervisory authority is the leading one. So when the Spanish authority got the complaint from the Spanish Consumer Association, which, as I understand, it then had to transfer this case to the Czech DPA to handle it. But in exchange, the Czech DPA then has some cooperation obligations towards the Spanish one. So it has to provide information, provide the draft of the decision for possible objections, which I understand from the decision is exactly what happened. So once the draft decision was made, it was then provided to the Spanish authority, and as no objections were raised, the Czech DPA was free to issue that decision.
Perfect, and that's, as you said, a perfect example of the mechanism between DPA when there are, cross-country cases. Going back to the case, and I think that the most interesting part, and what probably our audience would like to know more about, is related to the sanction that we have seen as potential sanction for Avast that is very high. So maybe we can delve a bit more on this sanction and why the authority has been proposing, let's say, or is pushing for that kind of sanction.
Well, for context, I think it's important to say that the sanctions here in the Czech Republic, the highest sanctions so far were in the range of tens of thousands of euros. So this is for us locally, this is a big, this is a big change. I have my personal opinion, which you cannot read in the decision for this huge difference. And that's more, I would say, political than legal. One aspect is that obviously this is a cross-border processing and you have other authorities involved. So I think the Czech DPA was felt a bit under pressure to align its methodology of calculation and also the level of fines with other authorities. So albeit the decision does not, I think, mention the EDPB methodology expressly, I think it followed that in a way. So it looked at the maximum possible fine that you can impose for the most serious infringement. It then tries to set sort of the baseline on the basis of that maximum possible fine, also the gravity of the infringement. The baseline was set, if I remember correctly, roughly around 8 million euros. And then it took into account some aggravating and mitigating circumstances. The most aggravating circumstance was that Avast itself is a professional in the field of privacy and cybersecurity. So the users would not expect Avast to trade with their data. So a baseline was raised by 60%. Another mitigating circumstance was the intentional aspect of the breach, another 30% on top. But the fact that Avast voluntarily switched from legal interest or legitimate interest to freely given consent decreased the fine. Maybe one note in that respect, I think Avast was really lucky that the Czech DPA concluded that it did not prove that special categories of data were involved. Should that be proven, I think the fine could have actually been even higher.
Perfect, and thanks a lot also for explaining this part of the maths, let's say, behind the sanctions, and of course, for sure, as you were saying, this is the first case, as you were mentioning, that has a more international level for Czech Republic, so it makes sense that they want also to align to the other DPAs, because that's what happened. I mean, we have seen with Ireland that there were other DPAs saying, oh, that's not enough. So there is a lot of discussion on that, trying to align and harmonize the position of the various authorities. Let's go back to the practical side of these. So my last question for you, Michal, would be, which are the key takeaways we can take and we can learn from this case?
Well, I would say that for any business, it's very simple. Don't do business with your users' data, and if you want to do such business, you better make sure that you obtain their freely given consent according to the GDPR, and that you are very transparent towards the users. If your argument, as this was the case here, if you want to argue that you use anonymous data, the threshold for anonymization is quite high, and simple removal of direct identifiers, especially where big data is involved, it won't do the job. And probably the last takeaway specific to this case, again, is that, if you are a company whose primary purpose, and if you present yourself as, having your primary purpose as protecting your users' data, then you must take special care. You need to be double transparent. You need to really understand that your users that would expect you to protect their data, understand that in addition to protecting their data, you're using those data for business purposes.
Absolutely, and thanks a lot for this, and I couldn't agree more in any point. In particular, the one on anonymized data is still a concept that is really under discussion. Probably too much to rely that much on it. But Michal, thanks a lot for being with us. We are running out of our time, so it was a pleasure. Thanks for the overview. That was extremely clear, extremely concise, and I really look forward, to hear more about the development of this case. So I would say we stay in touch. And thank to our listeners for being with us today. And I look forward to meet you all for our next Privacy Espresso. So bye, Michal. Bye, everyone.
Thank you. Bye.